Wade. The Constitution obviously doesn't say anything about abortion. There's no abortion provision in the Bill of Rights or anywhere else, right?
That's exactly right. Nowhere in the Constitution can you read the words abortion. And nowhere do you find the words qualified immunity. You do find the word immunity 2 times. They use the word immunity 2 times in the U.S. Constitution. But it doesn't have to do with government claiming immunity. You have the Privileges and Immunities Clause, and you have the Privileges or Immunities Clause. And one says that the privileges and immunities of other states are to be respected, and then the other one says that privileges or immunities are to be respected. So both of those immunities have to do with individual freedoms. One's from the 14th Amendment, the other one's from the body of the Constitution. Both times that the word immunity is used in the U.S. Constitution, it does not mean that the government can do as the fuck as they please and they get immunity for it. It means that your right to speak, your right to wear a t-shirt that says, fuck Amy Coney Barrett. If you're an American citizen, you get to wear that t-shirt. You're immune from prosecution because you have the legal protection of the freedom of speech.
Right.
So does that just mean from an originalist perspective, case closed, abortion is left to Congress or left to the states, and that's all that needs to be said?
No, because the Dobbs decision applied a framework. It actually isn't an originalist decision because it's building on precedent. So the Dobbs...
Yeah, you goddamn fucking idiot! You fucking fool! He's like, hey, so it doesn't say abortion, so therefore that's it, huh? You looked at the Constitution, there's no abortion in there, and you're like, fuck goddamn abortion, huh? Is that what you were doing? And she's like, no, it's not an originalist opinion. So actually, I don't even know if they said that they went back and saw the damn thing. She was saying that it's using framework, it's using precedent. So there was the quickening, right? There is something about some originalist. There is some originalist discussion. But she's saying that the framework, the precedent framework that they're using is substantive due process. And, people have problems with substantive due process. We'll get into it in a second.
Dobbs' decision was interpreting the 14th Amendment's Due Process Clause, which says that no person shall be deprived of life, liberty, or property without due process of law. Because to the extent one might argue that there is a right to an abortion in the Constitution, it's located in that clause. That's where Roe found it.
Can we just make a comment? She's got some really nice recessive features going on. The blue eyes, the red hair. It doesn't even look like she really put herself together. It almost seems like she just probably woke up and just kind of dragged a brush over her hair. It kind of looks like she did just wake up. She woke up, put on a blouse, put on a blazer, put on a couple of pearls, took a brush to her hair, and then showed up for this interview. She's pretty, though. Amy Coney Barrett. She's a right-winger. She's conservative. But is she fascist? Because I can't stand a fucking fascist piece of shit. Fucking fascist piece of shit. You can be conservative. We've been debating liberal versus conservative since the beginning of time. But I think there's a lot of motherfucking Republicans that don't know the difference between fascism and conservatism. Because you know what defeats fascism? Conservatism. Upholding the Bill of Rights. That defeats fascism.
That no person shall be deprived of liberty would be the relevant one there. And so the line of cases is known as substantive due process. And what those cases say is, yes, this phrase, no person shall be deprived of life, liberty, or property without due process of law, It sounds like, well, Ross, if I'm going to take away your car, I have to give you fair procedures before doing so. But the court has long recognized that it also has a substantive component that inheres in that word liberty. And so there are some things that the legislature can't take away, be it Congress, or the 14th Amendment applies specifically to the states.
I just thought of this. They want to say that it's pro-life, right? To be against abortion is pro-life. I know too many motherfuckers that are so-called pro-life, who's okay with the death penalty, who's okay with the death of Palestinians and Iraqis and Vietnamese. They're okay with the death of poor people. They're okay with the deaths of people without health care. They're okay with animals being, not just killed for food, but just animals dying, plants. There's so many people that are pro-life that don't give a shit about the life of plant, animal, or people. So that's branding. That's really good branding. But if we're to just take it on the face value that they're against abortion because they're in favor of life, well, then they could be, the due process. You can't take away life, liberty, or property without due process. That's what the 14th Amendment says. So therefore, the life of the fetus. Before you take away the life of the fetus, there's got to be due process. So in a way, Roe v. Wade had found the word privacy. It had found the right to privacy in the 14th Amendment due process clause. You have a right to liberty. Liberty means you have a right to privacy. Right to privacy says you get to take a coat hanger and kill that fetus. But using that exact same phrase, you could actually go the opposite direction. Before you terminate that fetus, I'm okay with abortion, but late-term abortion is fucked up. And then too many people, I want to say Hillary Clinton and some other people acted like, not only can you do abortions up to 9 months, but do you even give a shit once the baby is born? Do you think it's okay to just fucking murder? It's almost like, where's your line? Have you drawn a line? I get a right to abort the fetus even if it's 18 years old. I get a right to do that. No, you do not.
Liberties, to be clear, that are not themselves enumerated
That are not
in the
themselves
Constitution.
enumerated. Well,
so I wouldn't be against something like that, late-term abortion. Then there's got to be due process. So, you got to be able to have some sort of hearing, some sort of evidence, some sort of, the life of the mother, right? The life of the mother is at stake. Something, offer some sort of evidence about why this abortion needs to take place. To protect the life of the fetus, to protect the life and the liberty and the property of the fetus. They need due process before you could get rid of any one of those things. So you could use the same 14th Amendment to defend the pro-life position. Now this is interesting here. She's about to talk about enumerated versus unenumerated. So enumerated means specifically drawn out. The Bill of Rights says you have a right to speak, you have a right to petition, you have a right to peacefully assemble, you have a right to bear arms, you have a right to keep and bear arms. You have a right to kick soldiers out of your house, you have a right to demand a warrant, to be free from unreasonable search and seizures, to be free from cruel and unusual punishments, and on and on and on. So, we have a right to all the enumerated powers in the Bill of Rights, but substantive due process says that we have a right to more than just those freedoms in the Bill of Rights. And she's going to mention 2 or 3 things. She's going to mention the right to marriage, the right to raise your children how you want to raise them in terms of education. Something else she had mentioned, the right to contraception. So Griswold v. Connecticut. So you have a right to contraception, the right to get married, the right to have children, to raise your children how you want to. And then the exceptions are you do not have a right to assisted suicide. And you do not have a right for an abortion. Which is interesting. The right to assisted suicide means you have a right to end your life, but they're saying no, that isn't what... The 14th Amendment doesn't guarantee your right to end your life, it guarantees your right to life. It doesn't guarantee your right to death when you say so. So, just interesting, the ones that she picks.
To be tricky, and I'll try to avoid going into complete law professor mode, but that word liberty in the 14th Amendment does incorporate many of the guarantees that are specifically stated in the Bill of Rights and make it so that states have to respect, say,
right.
freedom of religion, the freedom from unreasonable searches and seizures, and so on. Because were it not for the 14th Amendment, everything in the Bill of Rights would constrain only the federal government. But yes, that word liberty does protect some content above and beyond things that are expressly stated in the Constitution. But you see the problem. I might think a lot of things are in liberty that you may not think are in liberty, that one would disagree with. And there's a lot of risk. And this has been a very contested area of constitutional law for a long time. There's a lot of risk in making judges the final arbiters of exactly what the content of that word liberty is.
And so, she said something interesting there. For like 100, 150 years of the beginning of our nation, before the Civil War, before the 14th Amendment passes in what, 1871? Or is it 1868? Shortly after the Civil War, in the 1800s, she was saying that you only have a right to speak, which means it constrains what the federal government does. The federal government cannot arrest you for speaking. But the state governments were allowed to break the Bill of Rights. What? Where the fuck does it say that at? Well, you're allowed to say what you want to say, and us and the federal government can't tell you no, but the state governments can fuck you the fuck over. Why would that be? Why would that be? That makes no goddamn sense. It's such horseshit. But she does acknowledge that the 14th Amendment means that the Bill of Rights now applies to the states. So, we get to the same conclusion, but ultimately it's kind of like, what? Look, the federal government's not allowed to do cruel and unusual punishments, but if the state wants to tie you by your legs, drag you around by a goddamn backhoe, sling you over the limb of a tree and pound on you like a piñata, well, that's their right to do. The states have a right to cruel and unusual punishment. No, they don't. No, they don't. But the 14th Amendment now applies to the states, so the Bill of Rights do apply to the states, to state government, so the Bill of Rights are both a restriction to both federal government and state government.
So in an effort to reconcile this idea that the Supreme Court is neither a constitution maker nor a democratically representative body in much less branch of government, the test says, well, if there are some things that are so deeply entrenched and so fundamentally a part of American society that they go without saying, we don't need to enumerate them, we don't need to say them out loud, then those are the kinds of things where it's just widely understood, so widely understood that we don't have to put it in writing, we don't have to commit it to paper, commit it to parchment, so to speak. Then those kinds of things inhere in that word liberty, and they have the status of constitutional guarantee. But that's a small step.
What would be some examples of those kind of liberties apart from the abortion question?
Marriage, the right to direct the upbringing of one's children.
The right to marriage comes from Loving v. Virginia, Obergefell v. Hodges, and Turner v. Safley. The right to decide one's child's education comes from 1925 Pierce v. Society of Sisters and 1923 Meyer v. Nebraska.
These are all ones I'm pulling from precedent. The right to use contraception.
The right to use contraception in sacred marital bedrooms is Griswold v. Connecticut. Now, she's not going to mention a whole bunch of freedoms that we do have by precedent. The right to privacy is there, according to the Mapp v. Ohio 1961 case. The right to Miranda warning, which is Miranda v. Arizona. The right to the privacies of life, Boyd v. U.S. The privacies of life, the right to privacy, the right to privacies of life. That's 1886, Boyd v. U.S., Mapp v. Ohio 1961. The right to have children. 1942, Skinner v. Oklahoma. So you have a right to have children and you have a right to educate your children, how you want to educate them. There's also the right to reject life-saving medical treatment, the right to refuse surgery or forced administration of drugs, the right of expressive association, the right to security of one's home, the right to bodily integrity, the right to unanimous jury notes. That's a recent one, 2020 Ramos v. Louisiana. The right to the exclusionary rule. If evidence is gathered illegally, then it cannot be admitted into evidence. That's the 1914 Weeks decision. Weeks versus what? I don't know. 1961 Matt v. Ohio also. The right to self-defense, D.C. v. Heller. The right to not be sterilized without your consent. The right for two consenting adults to have sex in the privacy of their own home. And the right to reside with one's relatives. That's Moore v. East Cleveland, 1977.
The court has said that the ones that are not included are the right to assisted suicide, the right to abortion.
The right to assisted suicide, that's Glucksberg v. Washington.
I think those are probably the two most prominent ones that have been held not on the list.
Right. And you were one of the people who held that the right to abortion was not on the list. Why?
Yes.
Franklin University makes it possible.
Be unstoppable with a master's degree from Franklin University. As the top choice for over 10,000 busy adults.
Good
Franklin's
deal
master's programs
better.
are proven to fit your
A
life
good
and
deal better
Choose from nearly
at
20
John
programs
Nolan
in business,
Ford.
Because given the test, so that the test, as I said, these are rights that are so widely understood to be fundamental that they go without saying. The test is that before the court will recognize such a right as an unenumerated constitutional guarantee, it has to be stated at a specific level, because if you state something at a broad enough, like right to control one's body, that could include a whole lot of things. Everything from assisted suicide to abortion to
drug use
exactly,
laws against. Yep.
Exactly.
The right to bodily integrity is actually protected to 1952 Rochin v. California. And then he's talking about drug laws. You have a right to your own body. Like, that's natural law. That's just obvious. It's common sense. You don't have a right to your own body. Well, then who does? Who's got a right to my body? Well, that person, that guy and that lady, and then that group of people, the Congress. Congress has a right to your body. No, they do not. So according to Rochin v. California, 1952, Rochin, R-O-C-H-I-N v. California, 1952, you have a right to bodily integrity.
So you have to state it at a specific level of generality, because it's also only if something is identified precisely that you can really measure what the degree of buy-in among the American public is. And that it has to be deeply rooted in this country's history and tradition. You know, it can't be a Johnny-come-lately. The case, I talk about this in the book, Washington versus Glucksberg is the name of the test. For purposes of this test, it's not an originalism thing. It's not just frozen, at the moment of the ratification of the 14th Amendment. This is actually looking, more deeply at the history and traditions of the American people. And abortion failed that test. The right to an abortion failed that test because it's been a deeply contested issue. It certainly was in 1973 when Roe was decided and continued to be contested. Casey versus Planned Parenthood, first, that's the case in which the court first confronted the question of whether to overturn Roe versus Wade, prior to Dobbs. And Casey, the controlling opinion, did not say that Roe was right, but for reasons of stare decisis, which I assume you're going to want to talk about precedent later, said better to just let this lie because we're hoping that this will just bring both sides of this controversy together in America, and let's just say, now it's settled, it's a truce. Well, that didn't happen post-Casey. The right to abortion has continued to boil our politics. So what the court held in Dobbs was that it could not be said that the right to terminate a pregnancy was one that was deeply rooted and was considered so fundamental by a supermajority of Americans that it didn't even need to be said. It went without saying.
But they're using that test, right?
With Uber for Business, you can set budgets so easily, your team actually sticks to them. Even Shane, from sales.
It's from Interesting Times with Russ.
History beyond just
that.
Legal history also becomes relevant, surely, right? Like the condition of debates about abortion in the 19th century become relevant to that kind of test, right? Put it this way, I think it is very reasonable to look at the history of the abortion debate over the last 50 years and say the court tried to settle this case, it clearly didn't, there isn't a deeply rooted sort of pro-choice consensus in America, it's more contested than that. I think that's true. But it's a historical judgment. It's a judgment about public opinion, it's a judgment about a whole host of things that are outside the letter of the law.
So this test, this whole area of substantive due process is tricky for some of the reasons you say. That's been a criticism of the doctrine in general and a criticism of the general notion that we can have rights that the Constitution doesn't specify precisely because of the kind of inquiry that it invites judges to undertake. But Dobbs didn't question that. Dobbs accepted that there is this doctrine of substantive due process and he did not.
Do you question that?
Well, now, Ross, you're asking questions that I can't answer. No, I'm very careful in the book, and I'm always very, very careful. You know, I apply kind of confirmation hearing rules. So I take everything, and I do in the book in my discussion of Dobbs, take the law as I find it, you know, as it is. And I will say, I mean, so I think you're right that as a matter of theory, this inquiry about is something deeply settled in this country's history and tradition. I do think that inquiry could sweep more broadly than just the law, but as a practical matter, in the cases, and there are just kind of a handful of these substantive due process cases, the court has focused primarily on the law and primarily on the existence of abortion restrictions, for example, in Dobbs. Like the court could detail and could look at, because that's
right. You
don't
say
have to
here,
look that
right?
far.
There were abortion restrictions in the 19th century, in the 18th century, and so on. And
when Roe was decided,
and when Roe
almost
was decided,
every state had,
right.
still
Obviously.
had prohibitions in place.
Well, at the risk of not getting definite answers, sort of confirmation hearing style, I am just interested in pressing a little bit on both the limits of originalism and also just the places where